everybody's responsible for that. That's a lot of work. But if you have a select group of individuals that are looking for those changes, it'll help implement it throughout your whole store.
Let me ask a question that really just throw it out to any of you that want to answer it. But presumably my business is renting space from someone. Is there any duty that any increased or enhanced duty that the landlord has? Do I have any rights? Am I just looking at the lease? I mean, things have changed. Do I have a right to say to the landlord, I expect the bathrooms to be cleaned certain days and in certain ways and things like that? And if I'm a landlord, ought I be concerned about this duty?
I think again, you want to focus on what's reasonable. When you're having people come in to look to see if this is a space they want to rent, and they're taking tours, you don't want to have an open house, so to speak, where you have all people shuffling in and out. Schedule them 10 o'clock, 11 o'clock, 12 o'clock, so you can space out the amount of people coming in and out. And, there's going to be certain things that people are touching. If the office space has a kitchen, they might be opening up that fridge to look at inside. So that's an area you want to clean each time someone comes in and out. Do you need to clean every light switch? Maybe not. But again, be reasonable. If it's a small space, maybe. If it's a big entire floor that you're renting out, probably don't need to. And then, I've seen this recently. You have to sign a waiver or an acknowledgement before you're allowed in to look at the space. That's something that you can think about doing too.
Another point I'll add to that is if you're thinking about you're an office and you rent space in a larger office building, one of the key things in that context is going to be communication. And so a lot of businesses, probably one idea that they might implement to further social distancing will be staggering times that employees arrive at work. But that's only going to work if you're communicating with everyone else in the building, and the landlord should really be in a position of trying to facilitate that communication and make that happen. So it's not going to work if you only one business in the whole building is trying to stagger employees. That it's not going to be helpful if you have some of your employees arrive at 9 a.m. and everyone else in the entire building also has an expectation that every employee arrive at 9 a.m. So communication will be key, and you might want to work with your landlords to have them open up stairwells, maybe put signage that says like, use this stairwell to only go up and this other stairwell to only go down. I don't know that there are actual legal requirements that would require a landlord to follow each of those steps, but it all ties into this reasonable analysis and just having a good relationship between the tenant and the landlord.
And sorry.
Also, once you've rented out the space and they've signed and they're taking possession, I think that really the landlord then has less responsibility in keeping that space clean. It's now transferred to the tenant, and you can put into the lease language to that end. There's commercial general liability policies that cover communicable diseases. You can put in there to have your tenant have a communicable disease coverage in their CGL policy. I think it's going to be hard now to get coverage for that, but that is coverage that exists, that has existed for a long time. And that's another thing a landlord can consider when they're renting out their space.
So let's move on to some specific examples of concerns that employees and employers would have. And the example I'll give is assume I have a gentleman working for us. He's 65 years old, so he's kind of in the target age group. He's overweight. He thinks Cheetos is a health food. He doesn't work out. He's a smoker. I know that he is a prime candidate. He looks to me like he doesn't really practice social distancing. At what level am I interfering with his health privacy rights, his rights as a human being, and I'm, as an employee that's allowed to manage his own life? At what level can I impose greater standards on him? Can I require him to do certain things? Can I suggest to him that we're letting everybody else in the office this month, but we're going to wait on people that are higher risk like you? Michelle, do you want to start? And Marni, everybody jump in.
Absolutely. Yeah, I think it's twofold. I definitely think that should be looked at when you're discussing who's going to return to the office and who isn't. It also depends on whether it's an essential function. So in some cases, this employee maybe isn't able to work from home. The only job that they have is at the space, the brick and mortar space, and therefore, if you're ready to open and you need that position, then you're going to need to bring them in. If you do decide to make accommodations for people that you would categorize in a high risk zone, then I would make sure that you set the policy for it or protocols for it, and that you be consistent with it. But again, I would also, being in HR, if I were to counsel a client on that, I would want to get some legal advice.
Marni,
I'll
can you give
jump
us that
in.
legal advice?
I can provide some of that legal advice to this hypo, not to any specific situation.
Right.
But the first thing I would do is caution against coming up with any type of policy that would actually ban someone who's in a CDC high risk category from the office, whether it's because they're 65 or because they have some other type of medical condition. If you do so, you're walking right into a discrimination lawsuit. The EEOC has spoken to this exact issue. They have guidance on their website that really emphasizes the need to engage with each person one-on-one, discuss their actual situation, not just say, you're a diabetic, now you can't come to the office. And some people hear that and they're confused maybe at first, thinking, I don't want to come to the office. I'm so scared to come to the office. Isn't that a great thing? How are you discriminating? And it becomes an issue because you are, well, that's some people's perspective. Other people are anxious to get back to work. There's pay consequences, promotion consequences. There's a lot of reasons that that would be a really iffy and probably just illegal policy to have. But what you can and should do in that circumstance where you have employees who fall into these high risk categories is you should invite all of your employees to reach out, whether it's to someone in HR or someone else at the office, to request accommodations and to engage in the interactive process to figure out if they can continue to work from home, if they should. And you can have a policy where you're presumptively going to grant an accommodation to work from home for anyone who is high risk. But you want that to be their decision. You don't want to impose that on your employees, saying you must work from home or not work at all.
Well, that's curious. So what happens if I have an employee who, for whatever reason, but look, I'm scared to go out. I mean, so I have an employee that says, you know what? I hear you. I read your rules. I want to come back to work. I've been working. You know, it's satisfactory for my home. Maybe not. It's maybe not optimal, but I'm just scared to come in. I'm not happy with the exposure. Do they have the right to say that? Do I have the obligation to respond to that? How would you advise both the employee and the employer in a circumstance like that?
For the most part, an employee in that situation doesn't have the right not to come in just because they're scared. There's two main exceptions to that. One of them would be if they have a reasonable belief that there's an imminent threat of death or serious injury. And that's a really high standard to meet. So yes, there is a risk of COVID out there that can lead to death and serious injury. But if you as the employer are taking all of the steps required of you to reopen under the different local ordinances of what it takes to reopen, the employee probably is not going to reach that threshold. The other exception would be you might have an employee who is scared to come to the office and they actually have a medical condition like anxiety. And if they come to the office, they will have an anxiety attack. And now they've gone from being just an employee who's scared to an employee who has a medical condition that you do have a legal obligation to accommodate. And you can request medical documentation for that, but you should be aware that there's fear and then it kind of falls into a different bucket if it actually is a medical condition. But let's just say you have the scared employee. So it's not someone who falls under either of those exceptions, the first step you should take is to communicate with that employee and try and figure out what's the basis of their fear. That might lead you down to, this is a medical condition, or it might be that they're scared that they're not going to be able to practice social distancing, and you might be able to address those concerns. And you, at that point, I would engage in a conversation about what kind of on-site accommodations can we make to alleviate the fear. And that will just make everyone happier, the employer, the employee. But if that, let's say that doesn't work and the employee is still just too scared to come in, at that you could consider, as a matter of policy, allowing the employee to work from home. And that's going to depend on what the employee's role is. So if it's a receptionist and you have visitors coming to the office now, you might find that you actually can't accommodate the receptionist's request to work from home because it's an essential function of her job that she be there. At that point, I'd say there's some other options you can consider, such as transfers to another position, leaves of absence. You can do, yeah, there's, I mean, I'd say that you're getting now towards the bottom of your rope, where termination would potentially be the next thing on the list. But that's what that conversation would look like.
Let me ask, we're talking about sort of the social distancing, and there's been a lot of news about people can't seem to get, there's a plexiglass backup, you know, that you can't get plexiglass. People are putting sheets in their offices, and everybody's got their own opinion about what they should or shouldn't be doing. But let's say that we actually can have some sorts of rules, and we tell the employees that we want them to practice social distancing. And let's say there's that one guy who just likes hanging around and stops at people's cubicles and chats them up and is, you know, outwardly violating these rules. And you have an employee come to you and say, you know, I'm really not comfortable, or you see that they're doing it and you're not comfortable. Ordinarily, you would have sort of escalating sanctions for someone. First, a verbal notice, then a written notice. Well, in this case, people's health is exposed. So how do I handle that recalcitrant employee? Any of you?
Well, and I was sitting here, I was smiling because I've been getting asked this question a lot, is how people are concerned how they're going to performance manage now. Because if someone does come in and they're violating that 6 feet social distancing, you don't have time to go through a 3-step process, or even sometimes, as Marni has mentioned, in certain cases, you're going to do an interactive process. You may not have time. This may be imminent that you stop this and get this employee to follow the rules. There may be a situation where you have to ask them to leave. It could go to, you sit them down, you give them a strong warning. If it ever happens again, I'm taking you off premises, or I may, you know, proceed with some kind of termination. That there again, what I would do is have it be very clear what your new performance and disciplinary processes are going to be, so that if it does happen, that you'll be able to follow those guidelines and execute on them.
I'll add also, let's say it's an employee and you're a public-facing business, and let's say it's a grocery store, for example, and they don't like to wear the mask. They're constantly taking it off. You notice they don't wash their hands. Well, now they're putting third parties outside of the business at risk. And so we go back to that reasonableness standard. Are you taking reasonable measures to protect your customers? And if this is somebody that you know is breaking these rules and they will not stop, and somebody does get coronavirus and they can prove that it came from your store, and it comes out in that case, you had this employee who may have been spreading it and you knew about it, you're no longer taking reasonable steps to protect your customers. So, you know, that could be, you know, maybe going into the employment law issues, I don't know those, but maybe transfer them to a different department. Maybe they work in the back of the supermarket now instead of the front. Or maybe they can't come in anymore, but now you're putting third parties at risk and exposing yourself to a lawsuit in that sense.
Well, Marni, let me ask you about the employment risk and the risk of liability for the employer, because now you have an employee that's violating the rules. You have an employee that's scared about the employee that's violating the rules and is actually being exposed to a health risk. I'm used to sort of when there's unwanted sexual advances or things like that, and you have a duty to an employee. Is that the same level of duty here? How do I separate them from each other? Do I have an obligation to sanction the violating employee? Can I be sued by another employee who gets coronavirus, as Josh says, with a customer coming in?
So I agree with everything that Josh and Michelle said. And in the situation you're describing where you have the scared employee who's upset with the other employee who doesn't take the social distancing safety rule seriously enough, as the employer, in this context, documentation and enforcement are really your friend here. You want to, if you're going to have these safety policies, which you're going to need to have, you also have to enforce them, and you should document your efforts to enforce them. And that helps you with respect to liability you're facing from the employee who maybe you're putting out on unpaid leave. That employee might say to you, you did that because I'm 70 years old. You didn't treat the 20-year-old the same way who was also engaging in practices that violate our safety rules. So by documenting the reason for your decisions here, you can protect yourself from those kinds of discrimination cases. Obviously, you need to be treating similarly situated employees similarly in that context. So if you're going to discipline one employee for not wearing their mask, you should be prepared to do that with your other employees, whether or not someone is complaining about it. But if you do have someone complaining about it, then that person also is signaling to you, you have some risk there that they might, if you take an action against that employee in the future, they could say it was retaliation against them for raising safety concerns. And so you really want to cover all of your bases by enforcing your safety policies and documenting those enforcement efforts.
Let's move over to
Glenn. I just want to add one other thing. It's a real simple rule that we get a lot of questions on. If you're the employer and you're getting sued, there's tons of people who could sue you, but let's look at the employee suing you and the customer suing you. The customer can sue you. They can file a lawsuit in Superior Court and sue you. But the employee cannot sue you if they get coronavirus in most situations. That would be through workers' compensation. And you have to have workers' compensation insurance. And if they can prove, they don't even need to prove anymore that they got coronavirus from coming to work. There's now a rebuttable presumption that the governor signed off on that says it's a rebuttable presumption that they got coronavirus at work. Then the burden shifts to the employer to say, well, no one else here has gotten coronavirus. Your spouse has coronavirus, and a lot of people at their job has coronavirus. So they've now switched the presumption back onto the employee to prove that they got it at work. But in almost every situation, there's always caveats in the law, but an employee could not sue the employer if they got coronavirus. It should be, and it clearly is now signed off by the government, covered by your workers' compensation insurance.
Interesting.
I'll just respond to that too with a couple of the caveats there. One being, well, workers' compensation, it can actually be really useful to the employer insofar as it will bar the negligence lawsuits by employees. The employee could still sue for gross negligence or willful misconduct. And that's where it's really important that as the employer, you're taking all the safety precautions and that you're enforcing your safety policies. And if you're taking those steps, that can help defeat an actual lawsuit that would be based on not just you're not being reasonable, but you're being so grossly reckless here that the employee actually
like the one employee who's not taking it seriously and putting everyone at risk, and about it, that like Marni said, that potential exception for workers' compensation exclusive remedy rule.
Yeah, a lot of times what I will tell my clients is, your best defense is best business practice. And as both of you have said, being the legal minds in this, that's what I'm hearing you say is come up with something and stick to it. Don't deviate from it. Be consistent with it. Make sure it makes sense. Make sure it's taking into considerations the safety of employees and customers, and you're being consistent throughout your entire organization. Not that lawsuits won't come up, they will, but your best defense will be following those guidelines. At least that's what I'm hearing you guys say.
So let me ask about, while we're talking sort of about this, let's talk about the circumstance where someone actually has or could be exposed to the virus. So we're checking people's temperatures, we're asking people to self-report, we're doing the best we can. Somebody comes down with it. So there's a two-part question. The first part is, somebody comes down with it. What are my obligations as far as informing other employees? And should I identify the employee that actually came down with it, or is there a privacy issue? And then second is, if I tell them, look, you've got to get well and you've got to spend 14 days quarantining at home, what are my obligations as far as paid time off, unpaid time off? Marni, want to start with you?
Sure. I'll start with the first question. For most employers right now, local laws are requiring that you would actually inform other employees that they've potentially been exposed to coronavirus. I think contact tracing is now a term we're all probably fairly familiar with. And there's some best practices that employers can practice to enact those types of policies. So some employers are actually requiring employees who go into the office to keep a running list of everyone they come into close contact with. So within 6 feet for more than 10 minutes, every single day, the employee is supposed to write down each of those people and maintain that list for anywhere between 14 and 30 days. Keep it to themselves, but hold on to it. And so that way, if that employee ends up getting coronavirus, you can ask the employee, okay, give us your list. This is the reason we need it. We're going to reach out to each of the people on the list, and we're going to tell them that they may have been exposed to coronavirus based on their someone they've been in contact with. And that's the second key piece right there, is someone they've been in contact with. You should not go ahead and name that person. Doing so without the proper kinds of consents would definitely be a violation of privacy rights under various statutes and could get you into hot water. And there's really not a need to do it for the most part. There might be circumstances where you're a really small employer and people can kind of put the puzzle pieces together and figure out who it is. And the EEOC seems to have indicated there will be some leniency, even if someone's identity can be figured out by people who are going to sleuth and try and really figure that out. But otherwise, you're pretty safe if you're just going to say you may have been exposed based on someone who's been in the office and now has coronavirus or has a presumed case of it. And one other interesting approach some employers are taking with respect to contact tracing is actually using apps that they might require all employees to download an app, so that if I have the app and everyone on this panel has the app and we walk by each other, our phones recognize that we've been in contact with one another, if it's been for a certain amount of time. And then if later I upload my status into the app to show that I have coronavirus, the phone app will actually alert everyone else, you may have been in contact with someone. There's certain kinds of consents that are needed if you take that approach, but these apps actually might take care of those for you. So that's another option that employers can consider.
Marni, Michelle, did you want to jump in? I'm sorry.
Oh, I was just finding it interesting about those apps, and I was curious how you would be able to install something like that, because I could see, again, employees coming and saying, I feel like Big Brother's already watching me enough. I don't want an app on my phone. Now I'm being tracked every time I go to the bathroom, and they're going to write me up saying I go to the bathroom too many times. So anyway, I was just curious about that.
There are definitely policy concerns. So those are the options I'll throw out there. Whether it's right for your business or not is a separate question. Another legal issue, though, is you will have to reimburse employees. So if they have an app and it's using data, then you're going to have to reimburse for the cost of that.
Let me ask, what happens when an employee comes in and says, I've been exposed. I feel, my brother-in-law came over and socially distanced dinner at my house, and he came down with COVID, and I think I was sufficiently exposed that there's a risk. Do I, as the employer, look, Josh, what would you tell the employer in that circumstance? Would you say you must self-isolate? Does the employee have the right to say, I've decided to self-isolate and I have to respect that decision? We can go around the horn here, but Josh, why don't you start it off?
I'll pass the buck here. It's a little bit outside my wheelhouse on employment law issue.
Okay. We all did that in law school. Anybody else?
I can jump in there. So again, a little bit of a broken record here, but there are going to be employers who are required in that circumstance to ban the employee from the workplace, depending on the current state of public health guidance at the time. I believe where things stand right now, if you're in an office place and an employee comes to you with that scenario, first thing I would say is our policy is that you should have called. You should not have come into the office. Leave right now. So you don't want people who potentially have been exposed even coming into the workplace. You should have policies that stop them from doing that. But then, so if they say, I think I've been exposed, the California Labor Commissioner's Office has indicated that if that employee has accrued sick leave, accrued paid sick leave, then they can use that paid sick leave to quarantine for however much time the local health officials are saying they should in that circumstance. There also might be a number of other sick leave laws, some of which were passed in light of coronavirus, that they could potentially tap into. And it's good policy as well, even if you don't if you don't have to give the paid sick leave, you might want to anyways, because those are not employees who you want to be coming into your office. And the other piece I'll add to that is, if it's an hourly employee, you can't force them to use their paid sick days, but if they don't, then it would just be unpaid days in that context.
Yeah, I was going to just add to that there is that Extended Family Care Act, and it does allow for 80 hours, and it's got a list of things. These are for employers that are under 500 employees, private sector. And so there could be an opportunity if it's got like 6 different criteria. One is for if you have COVID or have been in contact with COVID, or even if you have to stay home with a child because the school's closed or daycare reasons, where they can get 80 hours. And that's above and beyond the normal PTO, vacation, or sick that they would get. It's only a one-time thing, and it lasts from now until the end of the year. So unless it gets extended, for instance, that is something that people can use. I had a question the other day where someone said, but what if they tell me they're sick and they need to quarantine, and I find out later that they were out water skiing and they weren't sick, or maybe they were sick, but they're still out there spreading it and not coming in. And so they said, well, what am I supposed to do now? Well, obviously, if they've said they're going to self-quarantine and you're honoring that, they're staying away for those 14 days, then wouldn't it be, if they're off doing something that they shouldn't be doing, it's not necessarily the employer's responsibility to manage it or control it, but would that be a performance situation? Because I just thought that was an interesting one. I mean, there are times where people take sick leave and they're not really sick, but they say they are, right? So what happens in a situation where they say they're quarantined and then you find out that they're out there and about? They just didn't feel like coming into work and they were exposed.
So I can speak to that. It does raise a really tricky issue. And if as you just explained, if that employee truly did come into contact with someone who had COVID, so they fit the criteria where your office says you can't come into the office for 14 days or whatever it is, I would really caution employers against actually disciplining the employee in that scenario, because there is a provision of the California Labor Code that prohibits employers from taking adverse action against employees for engaging in activities that are lawful. And so it depends. I mean, if you are, I think if you're in Pasadena right now, it actually might be against the law for you to go to the grocery store if you've been exposed to COVID during a certain amount of time. I don't know that we've actually reached that point in Los Angeles. I think that you are encouraged to quarantine. I don't know that it's actually against the law for you to do so. And so as an employer, you could actually be violating the California Labor Code if you were to punish an employee for going to the grocery store when they're supposed to be quarantining, or even for water skiing when they're supposed to be quarantining. And then another issue it raises, which is just another reason to enforce barring people from the office, but not trying to enforce an actual quarantine, is the pay issue. Because let's say you have an employee who works every day from 9 to 5. You don't control what they do at like 10 p.m. But if all of a sudden you're telling that employee, you can't leave your home at 10 p.m., then you're controlling that employee and presumably should be paying that employee for that time as well. So I would say, as the employer, don't try and fill the role of the public health officials of actually enforcing quarantines. Instead, just say, stay away from the office.
And Glenn, I'll try to answer your question now from a commercial perspective. Can you prevent people that you suspect of having coronavirus from coming in as patrons to your business? They're not your employees, but if they have a fever and you're screening for fevers, or they look sick, can you prevent them from coming in? And discrimination issues aside, I think that there's a real good argument to be made to prevent them from coming in. I saw in New York, they're saying that it's okay to prevent people from coming into your business for not wearing a mask. If somebody's got a fever, and we're all concerned about people with fevers, I think it's reasonable to prevent that person from coming in and asking them to come back any other time as long as they're not sick.
Okay, so we're heading toward the end, so I've got a few lightning round questions. Very brief answers coming from some of the participants today and a couple of my own. So let's start with, do I have a right as an employer to through policy, restrict personal travel of employees, or affirmatively require that people maintain quarantines after personal travel? Yes or no? And back it up, I guess.
No, same answer as what I just gave. If it's lawful for someone to travel somewhere, don't get into the business of telling them they can't travel somewhere. But yes, you can bar them from coming to your office for 14 days after they've traveled to a high-risk location.
Okay, so Michelle nodding her head. Oh, there seems to be a fair intersection of participants in this conversation in the real estate industry. So I've had several questions about, I'm a landlord and I have a tenant who is saying, I want you to do more work. I want you to clean the common areas. I want you to restrict the elevators more than you have. What sort of liability, and Marni touched on this in talking about, well, if you have certain rules about you got the blue team coming in certain days and the red team coming in other days, and they come in during certain hours, but willy-nilly, all kinds of other tenants are doing other things. Is there a point at which I, as a landlord, have liability to my tenants for doing or not doing certain things and not trying to coordinate the larger tenant base with each other?
This is a really good question, and it will take longer than an hour to answer. There are a lot of landmines in that question, but again, think about being reasonable. Somebody assigned a lease, they're paying rent to use that space. You can't prevent them from using their space for their intended purpose. but I think you can put reasonable limitations to ensure a safe workplace, not just for them, but for the other tenants of the building. I was in the office today. It was my first time in over 3 months. And in the elevator, the landlord had put 2 stickers, one in each corner, to indicate that they were 6 feet apart, to indicate like, okay, no more than 2 people should go into the elevator, and you should stand in these locations. And it's to make everybody feel safe. I've seen landlords put cup holders with cups of pens with like a rubber tip, so they could push the elevator buttons and take that used pen and put it in a dirty cup, and then they have maintenance come and clean those pens. Those don't cost much money. They're not that much work. They're reasonable measures. But to tell one business, okay, you can work on Monday, Wednesday, Friday, but then the other tenant can work Tuesday, Thursday, I think you're getting into really tricky situation, because they're paying you rent for 5 days a week or 7 days a week, but you're only letting them come in 2 days a week. And also, if you've signed a lease that tells you that the landlord will provide cleaning, well, and you want extra cleaning, well, I think if it's reasonable, especially these days, to come by and clean surfaces, I think that you should go ahead and do it. You don't want to be unreasonable. But if they want somebody every 15 minutes, 30 minutes, once an hour, I think that's unreasonable. And the common theme here tonight is what's reasonable. Do what's reasonable. And also, do you want to be the landlord that nobody likes? I mean, think about it from a policy perspective. Do you want these tenants to stay long-term? Do you want to have a lot of turnover? Those are personal questions that you have to ask yourself.
Okay, I'm going to do a couple more, and then I think we're going to call the game. Do I have any right? One of the questions that someone asked was, you're testing people coming into the office or the business, and you're doing you've got a questionnaire, or you're taking their temperature, you're asking them personal questions. It's very public. Do I need to be concerned at all that somehow I'm going to foot fault on disclosing personal health information that's private to other employees?
You should be concerned about that. That's one more reason you might want to have employees fill out these questionnaires from home. You should treat the information that you're getting as confidential medical information, the information being like someone's temperature or something like that. So it's the kind of information that you have to keep in a medical file rather than someone's personnel file. And you can't have temperature checks in a location where other employees can actually hear what someone's temperature is. You'll probably be violating policy and privacy rights if you do.
Yeah, and I was going to say, in some places, if you have a human resources department, this duty would fall under that. I would caution, if you don't have on-site human resources, I would also caution having an executive or senior leader in the organization doing that. I think that if you have to designate it to someone, I would try to designate it to someone neutral who does not oversee or manage others in a way that they might be looking at this like they're being treated differently because of that information, if you will.
All right, well, I want to be respectful of everybody's time. I have a couple of, first off, I want to say you've all been fantastic. There's a lot of information to digest here. We got through about 3/4 of the questions. There was just so much. I have a couple of housekeeping items. The first is to thank everybody for participating. The second is always support the Federation. The third is to remind everybody that this is not legal advice, that we have to pay lawyers to get that legal advice. So don't rely on any of this and tell your friends that the Federation told you what to do. And lastly, there is CLE credit available. There is a link that I think people got that you have to click on in order to register the fact that you participated in the program. With that, unless there is anything else that the Federation folks want to add, I'm going to thank everybody and wish everybody good health and happiness in these challenging days. Leah, do you want to add anything?
I do. I have one quick thing. Thanks everyone so much for tuning in tonight. I'm Leah and Leah Phillips. I oversee our legal network. And really quickly, the CLE code for tonight, which I know you need, is 640 288. I see Josh writing it down, so I know I was right with that. So again, the CLE code is 640288. And like Glenn said, there is a link in the follow-up email that you'll all be getting tomorrow. The link will be there for you to fill in the information. Thank you.
Thanks, everyone.
Thanks for having me.
Bye.